Any mention?
Please, Lordship. I beg to mention item number 12. Lordship, 12 and 13 are connected matters. So I pray if this matter may come up after 2 weeks.
You're making a mention on behalf of?
In item number 12, I am for respondent number 2 and 3. And in item number 13, I am for 1 and 2.
Yes.
I'm for state, my lord. I have no objections.
And the petitioner here? Who is petitioner here?
For the petitioner, Your Lordship.
12. You have no objection?
No objection, Your Lordship.
The matters on prayer made by Mr. So-and-so, Learned Counsel appearing for the private respondent so-and-so, not objected to by the Learned Counsel for the petitioner. This is matter after
2 weeks.
2 weeks.
Highly obliged, Lord.
Yes.
May it please, Your Lordship. I beg to mention item number 16, Your Lordship. I pray that this matter may be listed after 2 weeks, Your Lordship.
Yes.
No objection. 16 and 17.
Yes. Similar prayer for item number 17, Your Lordship.
No objection.
Order for the matters. Yes.
Highly obliged, Your Lordship.
Yeah, please, Your Lordship.
Yes.
I'm for item number 9, Your Lordship. We are seeking time for 1 week.
No
Yes.
objection.
Yes, sir. On request made. One.
Much
one-
obliged.
all right. Yes. On request made by the petitioner, not objected to by the respondents. Yes.
So, Your Lordship, I'd like to beg item number 8. I'm praying for adjournment. This matter may be listed after 2 weeks.
Why? Why?
Yes, maybe a lot.
The 2016 matter. Yes, sir. The request of the petitioner, not objected to by the learned government advocate appearing for the state. List after 2 weeks. Yes.
Must.
Highly obliged.
My lord, I beg to make a mention of item number 22, my lord. 22, this is a criminal appeal where the other two accused have also filed appeal, my lord, and those are coming up for motion tomorrow, my lord. So the paper books, so that these all matters can be taken up together once the paper, because all the evidences.
Once all matters are ready for hearing.
Yes, yes, my lord.
So what you want
2
now?
weeks time, my lord, because the other matters, 2 weeks time.
22.
22, my lord.
Yes.
21 also.
Arising out of the same judgment.
22.
Same prayer also.
21 also. 21 is there.
Same prayer also. So in both matters, 21 22, just say, just on the request made by the Learned Counsel appearing for the appellant, just after 2 weeks.
My lord. My lord. Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 19.
Yes.
I pray for 2 weeks' time, Your Lordship.
No objection, my lord.
2 weeks, the request made on behalf of the petitioner. Yes.
Highly obliged, Your Lordship.
Wait, please, Your Lordship. Also, I beg to mention item number 14. This matter may kindly be taken up after 2 weeks, madam.
No objection, Your Lordship.
14 also. Same. Yes.
Much obliged.
May I please, Lordship? Lordship, I beg to make a mention of item number 27, Lordship. I pray the matter may come up after 2 weeks, Lordship. I have taken consent from the petitioner.
No problem.
My lord.
Yes. 2 weeks at the request of the respondent. Yes.
Obliged, Your Lordship.
Highly obliged.
Your Lordship, I beg to mention item number 20. The conducting counsel is on sanctioned leave. Can it come after 3 weeks?
Who is the conducting counsel?
Jeshila.
After?
Jeshila.
After? When do you
After
want it?
3 weeks.
No objection, Your Lordship.
2 weeks. Yes. 20 at the request of the petitioner. Yes.
Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 24, Your Lordship. I pray that this matter may be taken up after 2 weeks, Your Lordship.
Yes,
Yes, Your Lordship. No objection.
yes, 24 same.
May I please, Your Lordship?
Hello, please, Your Lordship.
Item number 25 and 26.
Yes,
I'm seeking adjournment on behalf of Mr. R. Gurung. He's on his left. So, Your Lordship, kindly let us.
This was heard, and then there are two appeal in this. The one was heard, and the government was supposed to reply. I have prepared my main points of argument also, and the second case was supposed to be heard also, my lord. And if they are not
Your Lordship,
convenient, then
is
let
that arising out of the same judgment?
yes, my lord. Yes, so the two brothers.
We need to hear it separately because two separate grounds.
Two separate, more or less issues are covered, my lord. Just except for that, the only difference is that in my case, Louis' case, TIP was not conducted. Straight, my lord, we recollect, straight brought to the court. The other one, TIP is conducted. So 1 week, my lord, if it's not convenient, I have no objections.
Yes, Your Lordship.
25, 26, the request made on behalf of the state respondents. Let's this matter after 1 week. Yes,
Much obliged.
Obliged.
My please, Lordship.
Yes.
I beg to mention hearing number 4. This is with regard to CMJ University, my lord. Earlier occasion, Lordship deferred the hearing.
3 and 4.
Yeah, 3 and 4. And we had the occasion to speak to the counsel for the CMJ, who informed us recently that the CMJ has filed a review petition, but not yet listed. Now, my lord, according to me, it is not required to await the outcome of the review petition. However, in the meantime, we come to know recently that government has appointed the Joint Secretary Education Department to oversee the dissolution process of the university. Assets and liabilities you will take care of. So it may be appropriate if Lordship give me 2 weeks' time to obtain instruction from the party so as to implement this Joint Secretary.
joint secretary. What for joint secretary we implemented then?
Now here the government has endorsed him, assigned him the task to dissolve the university.
Yes.
Now
but-
he will dissolve it, taking into account the liabilities,
But then
assets and liabilities.
look after the process of dissolution. Does it mean that he will take over all the liabilities of the university?
My lord, he would have to oversee. My lord, definitely, that would be the duty.
Yes, Mr. Sulai. Anyway, let them.
Only 2 weeks' time, I'll take instruction. My lord.
Let them
Since they
file.
want to adjourn a matter, let the matter be adjourned.
We'll just whatever steps you take it. Then we'll
Yes, yes.
file an application. Definitely.
Yes.
We'll just say 4 and 5 both are same.
4 and
4 and
5
5,
connected
Lord.
matters.
Yes. 4 and 5. Just a London senior counsel for the petitioner prays for grant of further 2 weeks time. Prays for grant of 2 weeks time.
Yes.
Lord.
London AG appearing for the state has no objection. Pray allowed. List after 2 weeks.
Obliged.
Deeply obliged.
May it please, Your Lordship. Lordship, I beg to mention item 6, Your Lordship.
Item 6.
Lordship,
Yes.
Lordship, I pray that this matter may come up on Wednesday, Your Lordship.
Why witness? What is auspicious about Wednesday?
Lordship, as per instruction, Your Lordship.
Wednesday is a busy day, Lordship. Too many criminal matters, and Lordship sits in division bench.
That is a problem, yes.
Wednesday is a difficult day.
So it will go to next week.
Next week.
What next week? Next week, right? Why you do not want to? Why these matters are kept pending like this unnecessarily? Yes, we'll have it next week. This
Lordship,
petitioner list after a week.
item 7, Your Lordship.
7.
Lordship, in this matter, I'm praying for 2 weeks, Your Lordship. As per the last order, Lordship, I have to file an undertaking, Your Lordship. I have to file an undertaking, Your Lordship,
For what?
for giving no objection to the wife of the deceased petitioner, Your Lordship, to substitute the petitioner in the matter, Your
I have not
Lordship.
understood what you are saying.
Lordship, as per the last order, Your Lordship.
Petitioner passed away, no more.
Yes, Your Lordship. So I file a substitution.
You filed an application for substitution, isn't it?
Yes, Your Lordship.
So, you have,
I have to file not taking from the other legal heir, Your Lordship.
how many matters are there?
She has been tagged along together, Your Lordship.
So, in which matter you need to substitute?
161, Your Lordship.
161, item 7.
Lordship. The name of the petitioner is
There is
Dheren
no
Roy.
161, there is 261, there is no 161.
261, Your Lordship. My apology, Your Lordship.
Anyway, has it been recorded by the court that the petitioner has passed away in this matter?
Yes, Your Lordship.
That has been recorded.
My apology, Your Lordship. 260.
We do not know what we have recorded there correctly or not, then
It has been recorded in the order, Your Lordship.
just wait, let the matter come up. We'll just check the order sheets.
Lordship.
With three orders together, it becomes difficult.
Lordship. I will write.
Yes.
Item number 1.
Yes.
Please, Your Lordship. Lordship, here the petitioner's father was a retired government LP school teacher, Lordship. So he was drawing the pension, Lordship. And after his death, the mother was receiving the pension, Lordship. And mother passed away, Lordship, 29/8/2024. And the petitioner is a
Mother, the wife of the
wife of the pensioner, Lordship. Now the pensioner herein, he is the son of the pensioner, Lordship. Now as per the service rules, Lordship, Rule 48 of the Meghalaya Civil Service Pension Rules provides that if any son or daughter of the pensioner is suffering from any disability like mental or physical, then as per the Rule 48 of the pension, Lordship, rules that they are entitled to family pension, Lordship, for life, Lordship. I'll come to that page, Lordship.
Now you are here, you are a disabled person.
Disabled person, Lordship. My Lord will find the certificate, Lordship.
And what is the possibility? What is the percentage of your disability?
My Lord will come to page 23, Lordship. This is certificate issued from the district hospital, Ampati, Lordship, Southwest Garo Hills.
Yes.
My Lord will find C, Lordship, A, B, C, 80%, Lordship.
No, this certificate has been issued after the demise of the recipient.
No, my Lord. Yes, Lordship. As per the
No, what the service record of the deceased government servant says?
my Lord, that pension book is there, Lordship. That PPO, Lordship.
Yes.
That will find at page 1, Lordship. Annexure 1, Lordship.
Yes. Where are the details of the
Details, his name is
dependents?
not, my Lord, his name is not reflected. My Lord will find only mother's name is reflected. The type copy has page 15, Lordship.
If it is not entered, what can we do? Anyway, you just
My
take
Lord,
the
this is
instruction.
Lordship,
We'll-
naam, name, yes, Lordship.
See, there has to be claim has to be based on some genuine things. You just
My
cannot
Lord.
come after everything is over. Anyway, let us see. Heard Mr. S. Sheikh, Lawyer Counsel for the petitioner, issue notice, returnable in 3 weeks. MSS Bhattacharjee, Leonard G. appears for all the
Respondent number 1 to 4, Your Lordship.
One that I have served the copy to the Accountant General, Lordship.
Respondent number 5.
That is respondent number.
Respondent number 4 is Treasury Officer.
The respondent number 5,
five.
Lordship.
Okay.
5. 1 to 4 is government, Lordship.
So at 5 you take steps.
No, I have served the copy because there is a standing
But
council.
then how we will know they have? There must be some. Somebody from the Accountant General, if you have served, whom you have served?
We have served the standing counsel, Lordship.
So why you are not appearing then? Okay, so and so, respond number 1 to 4. State respond number 1 to 4 and record her name for respond number 5. Okay, stop the respondents. Shall the Lord and Counsel appearing for the respondent shall take necessary instruction in the matter. Just after 3 weeks.
3 weeks, Master.
Item number 2.
My lord, this also relates to pension matter.
What is the fact here?
The pensioner is the petitioner is the wife of the deceased who was working as an UDA in the office of the respondent number 2, Lordship. That is the Deputy Commissioner, Southwest Garo Hills. Now, while in service, Lordship, he died on 19/3/2023, Lordship. So his pensionary benefit has not been released, Lordship.
He was a regular.
Yes, he is a regular, Lordship. Yes, Lordship.
And he had completed that thing.
Because he was supposed to retire on
qualifying service.
Yes, Lordship. He was supposed to retire 30 April 2024, Lordship.
And you are the wife.
I am the wife, Lordship.
And your name appears in the service record.
My lord, obviously, my lord, that is the marriage certificate, Lordship. You will find at page 8.
No. What about the service record? Why you are referring to marriage certificate?
My lord, obviously, because there is no dispute, Lordship. Because service records.
We have to go by this in service.
Please, Your Lordship.
We do not.
Your Lordship, this marriage certificate was also issued after the demise of the deceased. And
This is
moreover, Your
something new.
Lordship, the marriage
Anyway.
certificate
My
doesn't
pension,
have...
Lordship,
If you
obviously.
find any false case, you see,
Obviously,
this
Lordship.
court will impose heavy cost.
Obviously,
Just
obviously, Lordship.
Your Lordship, if I may submit, Your Lordship, the petitioner has not even approached the department, Your Lordship, with the representation. So this
Yeah.
matter can be disposed and with liberty to them to file a representation.
That
Your
also.
Lordship.
No, why you have not approached the department?
My
and
lord,
directed
this is
you
a
are here?
this is not. I am not necessary. It is not necessary that I have to approach the department. The department knows that my date, Lordship. I am working. They should.
No. If in case,
I have approached. Though there is no written letter, Lordship.
Where is your reverment that you have approached?
It is not that. Although I have. Lordship will find para 7.
There is delaying the release. Where have you approached?
Para 7, Lordship. Although there is no written application, Lordship.
What para 7 says?
That the respondent authority in delaying the release of the pension after dues, other dues to the petition without any, even after repeated request. When I approach, because
Your
my
Lordship, this is just a statement.
is
Your
not that
Lordship.
far from. I went several times.
You take instruction. No
Yes,
problem.
Your Lordship.
Taking instruction will not be a problem.
Yes,
If
Your
you find
Lordship,
that there is any false claim, then we will definitely.
Yes, Your Lordship.
Obviously,
This
Lordship.
court is very severe with that. So.
And for
This
one
also-
respondents, 1, 2,
This
and 3.
also same order. Only
I have enclosed all his epic also,
MS
Lordship.
Nankindu will be for 1, 2, and 3, isn't it?
Yes, Your
yes,
Lordship.
And you will be for 4. Same order like before. Only these things. Same 3 weeks. Yes. Verify your things claim before
Yeah.
you approach court, Mr. Sheikh.
Yes, Lordship.
Obliged, Your Lordship.
Free.
Yes.
Yes, Lordship. Lordship, here the petitioner husband, he was a retired Gram Sevak, Lordship. And he retired, Lordship. He retired on Lordship 1994, and he was receiving the pension, and he died 15/2/2012, Lordship. Here in this case, what happened, Lordship? The wife, after the death, he sent a representation through registered post, Lordship, and she is an illiterate lady, Lordship. And after that, the matter was not followed up, Lordship.
Here also claim is for family pension.
Family pension, Lordship. My Lord will find at page. Here also her name is not reflected. Instead, her daughter name is reflected because she was the minor at that time, Lordship.
Who?
That daughter of the pensioner, Lordship.
Yes, but then wife's name comes first.
Why? Obviously, Lordship, but there may be error.
So your all cases seems to be very.
My lord will page 14 is the
suspicious,
representation.
Mr.
Later, my lord, there is no suspicious lordship.
No, why wife's name is missing in the service
My
record?
lord, she is an illiterate lady now 1994
See,
lordship.
it is not for her to enter her
Obviously,
name.
lordship,
Then-
it's true. It was incumbent upon on the part of the pensioner lordship, my husband lordship.
Yes.
My husband.
He served for so many years. He retires. After his retirement, also so long he received pensions. His name, wife's name is not entered
Not
there.
entered,
Is
lordship.
it believable?
Not
is it
entered,
believable?
lordship.
There must be a limit of you see things. Anyway, just yes.
But if there is,
I'm for 125, Your Lordship.
here we have sent to representation lordship.
There is no response.
No response lordship. The last one is page 15.
If any claim is genuine, then you should not delay in releasing pension.
And page 14 is the letter lordship she has written in the year 2012
Okay,
itself.
here
lordship.
also the same order.
Yes, lordship.
Up to 4 will be
125, Your Lordship.
no. Wait, 1 to 5 will be status.
Same,
payments.
same lordship.
1 to 5 will be status, payments, 6 will be accountant general. Same thing. He's taking instruction. Take instruction, and if you find that the claim is genuine, just do process. Yes.
Must.
Hearing item number 7.
Yes. What happened here?
Your Lordship, in this matter, you're supposed to file as per the last order, Your Lordship, on 2/05/2025.
Oh, it is this matter was taken up by different bench on
Yes,
the
Your
last
Lordship.
occasion.
Yes, Your Lordship.
Okay, let us see. Just a minute. So you are supposed to file it
Undertaking, Your Lordship.
an undertaking.
Yes, Your Lordship. We're praying for a week's time, Your Lordship. Since this wife of the petitioner, Your Lordship, she's staying in.
What about the other cases? What order has been passed in other cases?
Other cases, Lordship, this is
No, substitution is not required in all the cases, isn't
No,
it?
yes, Your Lordship.
Now, this is an order passed in. This is order passed in all the cases.
260, Your Lordship.
No, it says, see the order sheet 259. Read petition number 259 with Miss case number 64 of 2025. Then WPC 260, 216. All same orders.
Yes, Your Lordship. Since
In
you are
all
connected.
cases, you will be substituted. Same person will substitute.
No, no, Your Lordship.
Then?
Only 260.
Then
Your
there is a confusion. Then what will happen? Have you checked the last order?
Lordship. Yes, Your Lordship.
See the other files. How can it be? Same thing, same order passed, all the cases. So you will file undertaking in all the cases.
No, Your Lordship, only
Then this substitution is allowed in which?
in 260, Your Lordship. The
Then
petitioner.
why this order is passed in all 259, 260, 261, all matters. You should have pointed it out. That order is passed by a different court.
Yes, Lordship.
Where is the file of 264? Miss case 264. Oh, miss case 64 only. Miss case, writ petition, everywhere is the same thing. Same order passed.
Lordship. Same order.
Now this miscase in this order passed doesn't say specifically that where you are implemented. This is a common order for all the writ petition. That means you are implemented everywhere, provided you fulfill that undertaking.
Lordship, as per this order on 28/3/25, Lordship, in this order, it is submitted on behalf of the petitioner in WPC 260. Dhiren Sage Roy, the petitioner has died. So no
That's
application.
okay, but then come to order dated 2/5.
2/5, Lordship.
Yes. Does it say that you are implemented in one writ petition? It doesn't say.
No, Lordship.
So what is to be done? And how do we cure this defect? Yes, Mr.
Lordship, from my understanding, I think so. They have to file for recalling application for.
That was your duty also to point out when this order was passed. You all are silent. Allow the court to pass a wrong order. Your application also in prayer, nothing is said when he should be, where the applicant should be implemented. Para 1 it says 260. And rest not in your cost title, your prayer, all are silent. Doesn't say. There is no mention about in which writ petition. You have to file application for recalling order passed in those other two matters.
Lordship will do that, Lordship.
And in this recalling application, you have to make it specific.
Yes, Lordship.
You are not passing any order, we will just adjourn it.
Lordship.
You will fight it within a week.
Lordship, on a week.
Just say, in all the writ petition, just say one prayer made on behalf of the petitioner. And this is met after 1 each. Sheer negligence.
Apologize, Lordship.
Item number 10.
Lordship, item number 10 and 11. 10 and 11, Lordship, are connected matters, Lordship. We want to seek instructions from the client, Lordship, because there is certain development in the matter, Lordship. Lordship, I am praying, Lordship.
What is this matter about?
Lordship, the matter pertains to the teacher, my lord. Termination, Lordship.
Not termination.
Termination
Regularization, Lordship.
Regularization. Hindi teacher.
Garo's, Lordship. Their representation is pending, Lordship.
Before whom? Representation is pending before whom? And what is the date of representation?
Before the respondent number 2, Lordship.
Okay, Lordship, there
We
is-
were serving in the sanctioned post, Lordship, and to that effect, Lordship, representation has been made for regularization, Lordship.
It's a question of backdoor entry. An advertisement was issued for regular account. Against that, they had approved something.
Where is your appointment order? What is, on what basis you have been appointed?
Next one, page 14.
Page 14, Lordship, is the
What is substitute teacher? Who has been substituted? Who was substituted here? You've been appointed as a substitute teacher.
Lordship,
You've been appointed as a substitute teacher.
Lordship, in place.
So, meaning thereby, whenever regular teacher comes, you'll vacate. If you go by the normal interpretation.
Lordship.
Yes. So, and when this advertisement has been issued? When this advertisement was issued?
Lordship, 3/6/2020, the 2020. Lordship, the
3/6.
advertisement.
What is that? Where is that advertisement?
Lordship, at page 24. Annexure 10 at page 24.
But what is the current status of that
Lordship,
advertisement? Was it stayed at the initial stage?
it was not state,
It
Lordship.
was not. So what is the
But your
position now?
Lordship, I may be permitted to say, because petitioner does not have the requisite qualification for.
That is all right, but then we just want to know what is the stage, because this advertisement is 2020.
Yes, Your Lordship.
Now we are in 2025.
Yes, Your Lordship.
Now what happened?
This is filed in 21.
That is okay. What happened there? Consequent upon issuance of advertisement, whether any appointment has been made.
It is the, Your Lordship, in this regard, Your Lordship, in the affidavit, this point is not clear, Your Lordship. So I have to seek instruction regarding this, whether appointment is made.
Affidavit, when this affidavit was filed?
It is filed in 20.
Yes, but then what is the position now? This advertisement is not for appointment of Hindi teacher, isn't it? Was it?
It is this advertisement is an addendum to the original advertisement. This addendum is at page 25, Your Lordship.
Lordship, page 25, Lordship,
Is
it
the
says
main-
that assistant teacher Hindi 3 posts, Lordship. At
So you are aggrieved by this, page 25.
Lordship,
That is, you are aggrieved by that.
Lordship.
Assistant teacher Hindi, 3 posts.
Lordship.
Now what happened? 3 posts in which school then? You were serving in?
Dadangiri Puri Government High.
Okay.
Dadangiri Puri Government Higher Secondary School, West,
Dadangiri subdivision.
West Garavels District.
And then this is 27th November. You take instruction, what has happened?
Yes, Your Lordship.
Lordship, in fact, on the last occasion when the matter was taken up, Lordship has pointed out that what is the status of the.
No order. Lordship.
Yes, so then you
Lordship,
should
no
have
order is there
inquired.
though, Lordship.
You should have inquired about that. If someone is
that
appointed,
is-
then how, what?
Lordship. That's why, Lordship, I was seeking, Lordship.
Not only the age bar is also there.
Some cases are just filed for the purpose of filing. You kept pending like that. If somebody is out of service for such a long time, he should come to the court seeking immediate relief. Now here, you see, like ousted from service, challenged, and for 5 years also, it's remaining like this. Thereafter also, if you can make out a case, what relief you will be entitled to? Just tell us. If any regular employee is appointed, can you oust him just and then put you back there? Take about that part, the creation of third party right. Once third party right comes, you may, even if you have a legal claim, it may not be enforced in you.
But only thing is that he has been continuing till date.
You take instruction, or you are ready for hearing.
Lordship, let them take instruction, Lordship. We'll also prepare the matter, Lordship.
Please.
Is there any order passed earlier with regard to that? That you have
No
to take?
order, only
No,
adjournment
Lordship.
order.
No order.
No order is there to that.
Just start granted counsel for the parties. A perusal, it appears from the perusal of the materials on record. It appears from the perusal of the record that the petitioner is aggrieved by an advertisement dated 27/11/2022, whereby the post of the assistant teacher, whereby the post of assistant teacher in government of upper middle school under Dadangiri subdivision for the post of Hindi teacher was sought to be filled up by conducting a recruitment drive. Stop. Almost just full stop after full stop. Just say almost 4.5 years have lapsed from the date on which the advertisement was issued. Stop. None of the counsel representing the parties are in a position to inform the court as to what is the position of the recruitment sought to be made by the said advertisement. Stop. The Rana Council appearing for the parties shall offer instruction as to the status of recruitment of the post of assistant teacher within bracket Hindi in the matter before the next date. List after
3 weeks, Your Lordship, because it is from Tarangiri, Your Lordship, West Province.
2 weeks, Lordship. If you say 2 weeks, then 2 weeks. And if not, you let him take.
No, yes, sir.
List after 2 weeks.
Much obliged.
11.
Similar, Lordship. Item number 10, 9,
10 and 11.
10 and 11, Lordship, are similar, Lordship.
All Hindi teachers.
Hindi
Allowed.
teacher, Lordship.
Two different schools.
2 different schools, but same subdivision, Lordships, under the Dadangiri.
Same order will survive. And order, this advertisement is also same.
Same advertisement.
Same order.
15.
Much obliged, Your Lordship.
Yes. Have you filed your objection?
We have not filed objection.
So?
No, I'm praying for a week's time, my lord. So this morning I got a. They're preparing the instructions, my lord. A week's time I'll file.
No objection, Lordship. Week's time?
For 10 days, my lord. 1 week I'll file.
No, you take time, you see, but then the thing, make sure that you file it. It should not be something like that repeatedly keep on asking time, and it makes only the nothing.
Yes,
See,
ma'am.
the volume of the file becomes huge.
That's true, my lord. This
You see,
morning
in most of the cases, the order sheets are much more thicker than the petition. So that is what the problem is.
I'll file it by next date, my lord, whenever, Lordship.
No, when, that is 1 week will be enough for you.
1 week I'll file.
On the prayer made by Dr. N. Majiga, Learned DSGA appearing for the respondents. Further 1 week time is granted for filing the objection in this matter. List accordingly. Deeply obliged.
18.
Is it in?
May I please, Your Lordship?
Yes.
My Lord, the learned special judge, CBI, has been pleased to grant pardon to the respondent number 2 under section 306 in the CBI case pending before the learned special judge. My Lord, this order was passed on 25/1/2023, and being aggrieved, I am one of the accused in that case. My Lord, allegation was that I had sanctioned some fake bills for purchasing medicines and equipments. I am the head of the department of the NEHU, and under me the respondent number 2 was pursuing his PhD degree. So it is alleged that I have misused this respondent number 2 for purchasing materials and equipments from the farm which are fake. So the FIR, the complaint was lodged by the respondent number 2 on 22/11/2018, which is in page number 30, my Lord.
30.
30.
Yes.
My Lord, this complaint will be clear. I'll just read this complaint.
Yes, please. This is a complaint filed by the
Respondent number 2.
The person who has been granted pardon.
Pardon. Your Lordship, subject complaint against Dr. Such and Such, Associate Professor and Head of the Department, HOD of Biomedical Engineering Department, NEHU, Shillong. I am pursuing PhD at Biomedical Engineering BME Department, NEHU, and also functioning as a Junior Research Fellow in Department of Biotechnology, New Delhi, Government of India sponsored project title Design of Neural Network Based Pacemaker at Biomedical Engineering Department, NEHU. The principal investigator of the above mentioned project is Dr. Dinesh Bhatia, who is also an associate professor and head of the department of BME. Being principal investigator of the above mentioned project, he is my controlling officer. Being PI and HOD, Dr. Dinesh Bhatia is indulging in corrupt practice like sanction of false bill for a long time. Dr. Dinesh Bhatia has contacts with firms, namely Measures SK Enterprise, Riddhi Medical Store, Vansini Enterprise, AK Enterprise, etc., all situated at Sonbhadra, Annapara in Uttar Pradesh, in whose name Dr. Dinesh Bhatia sanctioned fake false bills for having purchased a medical electronics item. In fact, no such medical electronic items are being received by Department of BME, NEHU. Dr. Dinesh Bhatia himself has sanctioned such bills, being the competent authority. Dr. Dinesh Bhatia puts me under constant pressure to prepare fake bills and asks me to process the bill. After sanction of the bills, payment are being made to the firm in whose name false bills were prepared and sanctioned for supply of medical electronics item to Department of BME, NEHU. In fact, no such items were received by Department of BME, NEHU. Thereafter, Sri R. Gupta, mobile number, the representative of aforesaid firms, pays the bill amount to Dr. Dinesh Bhatia after deducting his commission by transferring the bills amount in my accounts. Later on, Dr. Dinesh Bhatia asks me to withdraw the money from my bank account and hand over to him. I am maintaining bank account bearing number such and such with Axis Bank, Lucknow branch, Uttar Pradesh. In this regard, I again submit that Dr. Dinesh Bhatia put me under constant pressure and threatened me that if I do not follow his instruction to deposit the illegal money in my account and to pay him in cash after withdrawing the amount from my bank account, he will discontinue my fellowship and get me debarred from my PhD. Due to constant pressure and threat, from Dr. Dinesh Bhatia. Now I am depressed and under tremendous mental pressure, and I do not want to facilitate corrupt practice of Dr. Dinesh Bhatia. Henceforth, Dr. Dinesh Bhatia henceforth, and therefore lodging this complaint regarding sanction of fake bills are and demanding amount thereof from me, which had been deposited in my account by Sri R. Gupta. I have been recording. I have been recording my conversation with Dr. Dinesh Bhatia for the past some time in order to collect the evidence and to prove my innocence. These recordings are available with me in micro SD card, which I can hand over to you if required. Recently, Dr. Dinesh Bhatia told me to prepare bills of amount rupees 1,30,000 approx in respect of supply of medical electronic consumable item which has not been actually supplied by Measures SK Enterprise, Riddhi Medical Store, Vidya Vansini Enterprise. As per his instruction, I prepared the bills and submit the same to Dr. Dinesh Bhatia, who has sanctioned the bills which were within his competency. After sanction of the bills, payment have been made to Measures SK Enterprise, Riddhi Medical Store, Vidya Vansini Enterprise. During the period from 4/11/2018 to 14/11/2018, I had visited my native place, village Syam Daspur, Hardoi, Uttar Pradesh for Diwali. Before proceeding on leave, Dr. Dinesh Bhatia ordered me to collect cash of rupees 50,000 from Sri R. Gupta, the representative of aforesaid firm. According to the instruction of Dr. Dinesh Bhatia, I contacted Sri R. Gupta, but he told me that at that time he did not have the cash, but he will transfer the money to my account or account of Dr. Dinesh Bhatia. After resuming my duty from leave, I joined the office on 15/11/2018. On that day, I told Dr. Dinesh Bhatia that Sri R. Gupta had not given cash, but told me that he will transfer the amount of rupees 90,000 to my account or the account of Dr. Dinesh Bhatia. On this, Dr. Dinesh Bhatia instructed me to ask Sri R. Gupta to deposit half of the amount immediately in my bank account, and about remaining he told me to wait for further instruction. However, I did not ask Sri R. Gupta to transfer or deposit the money on that day. On next day, 16/11/2018, Dr. Dinesh Bhatia again instructed me to inform Sri R. Gupta to deposit the money in my bank account. Hence, in presence of Dr. Dinesh Bhatia, I made call to Sri R. Gupta and told him to deposit cash of rupees 45,000. On 19/11/2018, an amount of rupees 35,000, rupees 5,000 and rupees 5,000 were deposited in my aforesaid bank account by Sri R. Gupta. On 20/11/2018, Dr. Dinesh Bhatia asked me whether R. Gupta has deposited money in my account. In this regard, I informed him that R. Gupta has deposited amount of rupees 45,000, but Dr. Dinesh Bhatia did not ask about the withdrawal of money as he was busy in some urgent matter. Today on 22/11/2018, when I visited office of Dr. Dinesh Bhatia, Nehu, he asked me to withdraw cash of rupees 40,000 to be given to him. However, today I could not withdraw the cash as I am holding the bank account with Axis Bank Lucknow branch, UP. Therefore, I opened new bank account number such and such with Axis Bank, Kitting Road, Shillong, where I transferred rupees 40,000. Subsequently, I withdraw rupees 40,000 from the ATM, which was deposited in my earlier account by said Sri Gupta towards payment to Dr. Dinesh Bhatia. Accordingly, I informed Dr. Dinesh Bhatia on his mobile about withdrawal, who has instructed me to hand over the cash to him in his office tomorrow on 23/11/2018 at 11 hours. I want to say that all the earlier proceeds of fraudulently sanctioned bill by Dr. Dinesh Bhatia have already been handed over to him fully after withdrawing from the bank account as per his instruction in the past, and I have not received any share part thereof from his directly or indirectly. Henceforth, I do not want to associate with the illegal activities of Dr. Dinesh Bhatia under his pressure and threats, and want to stop these criminal activities which are against the interests of Nehu. Therefore, I do not want to hand over the first above mentioned rupees 40,000, which is illegal money, as detailed above, and be part of this criminal act of Dr. Dinesh Bhatia. Therefore, I am submitting this complaint and request to take necessary legal action against Dr. Dinesh Bhatia. My lord, one of the name has been referred, R. Gupta, who is also an accused in the instant case. My lord, after this complaint...
R. Gupta is not before this court.
No. He is still there as an accused. My lord, after this complaint was filed on 22/11, 23/11, I was arrested. 23/11, I was arrested. And after investigation, which went for about 1.5 years, charge sheet was filed. And during the course of investigation, it was found that this respondent, the complainant herein, was also involved in the case. And his participation was much more than this accused person, because he was the one who has prepared the seals and who was having contact with R. Gupta, that another accused. And this Dinesh Bhatia was not having any contact with that person. So charge sheet is also there, my lord. The relevant portion is (42). My lord, paragraph number 3. During investigation, the specimen of seal impression of 3 rubber seals in the name of Measures Vindhya Vasini Enterprise, Measures Riddhi Medical Store and SK Enterprise, which were prepared from Measures Shillong Studio Shillong by the complainant, on the direction and under threat of accused Dinesh Bhatia, and the same were seized from the chamber of accused Dr. Dinesh Bhatia. The seal impression which are appearing on the forged bill raised in the name of above 3 firms were sent to CFSL Guwahati for comparison and opinion. The FSL expert has given a positive finding in respect of the matching of the said impression. Investigation revealed that as per Rule 145 of Chapter 6 of GFR, the principal investigator has the power to purchase good up to the value of rupees 15,000 without quotation or bid. There are 9 fake bills, including supply orders and sanction order for purportedly supply of different items to Nehu, issued under the signature of accused for total amount of rupees 1,30,000, were sanctioned by accused Dinesh Bhatia for the aforesaid 3 different firms headed by him as a principal investigator. So it is alleged that he has sanctioned the bill, but the bills were all procured by this this complainant. So my lord, the investigating officer found prima facie case against all the 3 accused persons, and all the evidence were collected. So now, my lord, after the charge sheet being filed, the special CBI learned a special judge took cognizance of the same. Summons were issued. All the 3 accused persons were appeared before the session. Now, on 4/2/2011, this complainant filed an application, who is the accused, now before the learned special judge. He himself filed an application before the special judge for granting pardon to him under section 306. So, my lord, one more thing. that Section 8, the Section 8 of the Prevention of Corruption Act.
Yes.
It appears that, my lord, CBI was well aware about the Section 8 of the PC Act, and that was the reason that they even make him an accused in the instant case. Section 8 of the PCA. Offences relating to bribing of a public servant.
Yes.
Well, offence relating to bribing of a public servant. Any person who gives or promises to give an undue advantage to another person or persons with intention to induce a public servant to perform improperly or a public duty, or to reward such public servant for the improper performance of public duty, shall be punishable with imprisonment for a term which may extend to 7 years, or with fine, or with both, provided that the provision of this section shall not apply where a person is compelled to give such undue advantage. Provided further that the person so compelled shall report the matter to the law enforcement authority or investigating agency within a period of 7 days from the date of giving such undue advantage. So, my lord, any person who has been compelled to give favor to the public servant, they are immune only if they report the matter to the authority within 7 days of his being compelled.
What is your locus?
My locus is, my lord, I am one of the accused and I am aggrieved because this, I am also in the same case, and I will be highly prejudiced if this complainant, this accused will be made an accused and he will depose against me.
Can that plea be raised?
My lord, there is, my lord, I may not have locus standi, but one citation I will place before this honorable court, which says that, your lordship, that even though the one of the accused may not have locus standi, but still the court can, once the matter is brought before the court, High Court.
Can and court shall, there are two different meanings. Show us the decision. Just wait. Show us. Is it decision by Apex Court?
Yes, my lord. Similar in the same
situation.
Yes. There are other portion also, but I will just take, my lord,
Come to the relevant
portion in this.
Useless going here.
Yes. Yes, my lord. Para 40.
40.
Page 239. This is 2013,
Yes.
15 SCC. So far as the entertainment of the case at the behest of the respondent by the High Court is concerned, we may state that he may not have legal right to raise any grievance, particularly in view of the law laid down by this court in Ranadhir Vasu versus State of West Bengal. However, the revisional power under Section 397 read with Section 401 CRPC can be exercised by High Court suo motu, particularly to examine the correctness, legality or probity of any finding, sentence or order, and as to the regularity of any proceeding of the inferior court. These two sections in CRPC do not create any right in favor of the litigant, but only enable the High Court to see that justice is done in accordance with recognized principle of criminal jurisprudence. The ground of interference may be whether the facts admitted or approved do not disclose any offence, or the court may interfere where the facts do not disclose any offence, or where the material facts of the party are not considered, or where judicial discretion is exercised arbitrarily or perversely. So, my lord,
which way it has? What relevance is this decision?
In the same facts, in the same situation, my lord, this is also case where the locus of the respondent, one of the accused, was challenged. But the Supreme Court has made it clear that, my lord, that that 397 and 4001 CRPC gives ample power to this honorable court to entertain even suo motu.
This is a proposition neither here nor there. You just cannot seek interference of this court by showing this. There is nothing. It says that it is open. It can be exercised suo motu also.
Yes, my lord.
Okay,
If
that is
the
all right,
whole
but then-
judgment was, my lord, in particular in this situation only, because that accused one of the petitioner, he has challenged the grant of pardon before the High Court, and it was the Honorable High Court was pleased to remand the case for a fresh decision on it.
And then what did the
And the
apex
Supreme
do?
Court said that 397 and 401 CRPC gives this court power to entertain even suo motu. Once I have brought to the notice of the court, then my lord can take that whether the impugn order was passed in accordance with law or not. So only my grievance is that, my lord, the materials on record was not taken into consideration. 306 CRPC, your lordship, the purpose of granting pardon is to obtain evidence. So, my lord, so far as section 8 is concerned, my lord, the matter has to be reported within 7 days of when the person was compelled. In this case, my lord, on reading of this complaint, it is already evident that, my lord, it is alleged that this petitioner was compelling this respondent number 2 since long, and only on 22/11/2018, that is almost after many days, he has lodged the complaint. And being aware of the situation, my lord, that's why the CBI also impleaded him as an accused. This provision of law was well aware and was within the knowledge of the CBI. That's why they impleaded him as an accused. So, my lord, now the impugn order, my lord, is it in page number 18. The relevant portion, my lord.
Page 18.
Yes, my lord, it starts from page 18, the relevant portion 28. My lord, the learned trial court, my lord, has only considered my objection instead of going into the merit of the case. My lord, in view of the paragraph
Page
28, page 28.
Yes.
Second paragraph. In view of the above decision, there is no merit in the objection raised by the accused Dr. Dinesh Bhatia. I raise an objection, but my lord, it appears that the main focus of the learned trial judge court was on my objection rather than on the merit of the case. Whether there was any
Your
circumstances.
Your objection was not based on merits.
My objection was based on merit, my lord, because my only simple argument was that what more evidence he can bring, and what more evidence the prosecution wants. When
No. What was your ground of objection before the trial court?
my ground of objection was that, my lord, there is no necessity to grant pardon, and there is no requirement of him obtaining any evidence further, because charge sheet has been filed, and there is no occasion. Even the CBI has not.
Where it is recorded, just show your objection. What you are saying, it's very, the court is not getting it. See, exactly. Tell us to the relevant part
Yes,
where the objection you have raised.
Yes, the accused paragraph, page number 20.
Yes.
The CBI filed their response stating that they have no objection to the prayer.
Yes.
of the petitioner, and he may be granted pardon under section 306 CRPC and be considered as approver. The accused Dinesh Bhatia filed his objection on the following ground: that the proposal to pardon Sri such and to turn him into an approver did not originate from the prosecution, as in the charge sheet the CBI made the accused Raghuvendra Pratap Tripathi as an accomplice, and a sudden changing course by CBI is causing prejudice to the accused. That the CBI, after considering the evidence sufficient, has charge sheeted all the accused person, including Raghuvendra Pratap Tripathi.
The same argument which you have raised here.
Yes, my lord.
These are the points you have argued just now.
Yes. And the evidence and assistance of Sri such is not required in this case to facilitate conviction of other, as he is the brain behind the alleged crime and was involved in the stage crucial to the commission of alleged crime, as there are material evidence in the form of interaction of Raghuvendra Pratap Tripathi with the other co-accused Sri Ranjit Kumar Gupta by deposing the proceeds of the alleged fake bills in his account. Also, his interaction and procurement of rubber seal from Measures Shillong Studio for using it in the fake bills and other documents shows his culpability as a principal offender in the case. That the accused Raghuvendra Pratap Tripathi has concealed in his FIR his direct involvement in procuring rubber seal in the name of three enterprises, namely such and such: Vidya Vansini Enterprise, Measures Riddhi Medical Store, and MS SK Enterprise from Shillong, Measures Shillong Studio for using it in the fake bills and other documents, which shows that he is not making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence. So by claiming that he will make full and true disclosure privy to the offence in totality before the learned court is something to be treated with caution. That the CBI, by not objecting to the petition filed by the accused for grant of pardon, was with a view to seal the accused, as in the charge sheet the CBI made the accused as an accomplice, and sudden changing course by CBI is perplexing and causing prejudice to the accused Dr. Dinesh Bhatia. That the accused Raghuvendra Pratap Tripathi has filed the application seeking to be an approver in order to save his own skin and not in order to help the cause of justice, as he has concealed material facts in the FIR, like that of procuring rubber seal in the name of three firms, and it would amount to premature vilification of the accused Dr. Dinesh Bhatia. That Raghuvendra Pratap Tripathi, being a trapped witness as well as seeking to be an approver, cannot be considered at all to be competent witness, he being a participant in the commission of offence by offering alleged money, shows a clear and malified and criminal intent of getting the Dr. Dinesh Bhatia implicated falsely. So, my lord, all these things has not been considered, and only since the prosecution given no objection, that they have no objection for giving pardon, the learned trial judge was pleased to grant pardon. And my lord, in this regard, the same judgment, my lord, same judgment, page number 235, para 26.
Yes.
It was contended by Mr. K.V. Viswanathan, learned ASG, that the court must invariably agree to tendering a pardon if the proposal to pardon originate from the prosecution or if the prosecution supports it. Since the prosecution, as in this case, support the plea of respondent number 2 for grant of pardon and for becoming an approver, the High Court committed an error in reversing the order of a special judge. If this contention is accepted, it would completely marginalize the role of the court and take away the discretion of judge in ensuring a fair trial and doing justice in a criminal case. We therefore reject the contention. The aforesaid view stands fortified by the judgment of this court in Santosh Kumar Satish Bhushan Baryar versus State of Maharashtra, wherein it has been held that order of pardon cannot be passed mechanically and the court has to apply its mind while exercising such power. In Baba Fakir Singh versus King Emperor, while dealing with the issue of grant of pardon under the provision of old code, it was held that tendering pardon under the provision of section 337 a judicial act and under the special precaution rules and consequence which the statute set out. My lord, so not only merely on being objected or consented by the prosecution, the court has to see, my lord, that whether such requirement is applicable in the facts and circumstances of the case. The court has to apply its own mind. So now section 306 CRPC is verbatim to section 337 of the old code. There is no change at all with respect to the power to grant pardon. More so, exercise of judicial power in relation to grant of pardon is required so as to remove any suspicion of political consideration or to ensure that pardon is in the interest of justice. So, my lord, 30 also, paragraph 30, the concept of public policy was explained by Lord Mansfield in Holland versus Johnson, observing that the principle of public policy is ex dolo malo non orator action. No court will lend its aid to a man who found his cause of action upon an immoral or illegal act. If from the plaintiff owns stating or otherwise the cause of action appears to arise ex turpi causa or the transgression of a positive law of this country, there the court says he has no right to be assisted. Paragraph 33 is also relevant, my lord. In view of the above and considering the judgment of Privy Council in Baba Fakir Singh, we are of the view that grant of pardon by court under section 306 CRPC on being asked by the accused and duly supported by the state is a judicial act, and while performing the said act, the magistrate is bound to consider the consequence of grant of pardon, taking into consideration the policy of the state, and to certain extent compare the culpability of the person seeking pardon qua the other co-accused. But in the instant case, no such observation or consideration has been made, my lord. My lord, one more decision of the Punjab and Haryana High Court. It is.
If it is covered by this, then what is the purpose? Yes, Dr. Mujika.
My lord, I'll refer to the findings of the learned court below, my lord.
Yes.
My lord, seen the order starts from page 18. My friend has referred to the submission, their submission, my lord, before the learned trial court.
Yes.
Page 22, my lord.
Yes.
After, till the point Mr. Pandit read, my lord, at page 22.
Yes.
Then I'll read, my lord. In support of his contention, the learned counsel relied on the decision reported in Lieutenant Commander Pascal Fernandes versus State of Maharashtra so and so. Then Section 306 has been quoted, my lord. I may skip this part. May I read, my lord, section 306?
If you want, that there's purpose of reading, definitely why not?
306, tender of pardon to accomplice. With a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offence to which this section applies, the Chief Judicial Magistrate or Metropolitan Magistrate at any stage of the investigation or inquiry into or the trial of the offence, and the Magistrate of the first class inquiring into or trying the offence at any stage of the inquiry or trial may tender a pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence, and to every other person concerned, whether as principal or abettor in the commission thereof. This section applies to any offence triable exclusively by the Court of Session or by the Court of Special Judge appointed under the Criminal Law Amendment Act. Any offence punishable with imprisonment which may extend to 7 years or with a more severe sentence. Every magistrate who tenders a pardon under subsection 1 shall record his reasons for doing so, whether the tender was or was not accepted by the person to whom it was made, and shall on application made by the accused furnish him with a copy of the such record free of cost. Every person accepting a tender of pardon made under subsection 1 shall be examined as a witness in the court of the magistrate taking cognizance of the offence, and in the subsequent trial, if any, shall, unless he is already on bail, be detained in custody until the determination of the trial. Where a person has accepted a tender of pardon made under subsection 1 and has been examined under subsection 4, the magistrate making cognizance of the offence shall, without making any further inquiry in the case, commit it for trial to the Court of Session if the offence is triable exclusively by the court, or if the magistrate taking cognizance, if the Chief Judicial Magistrate, to a Court of Special Judge appointed under the criminal law so and so, if the offence is triable exclusively by that court. In any other case, make over the case to the Chief Judicial Magistrate, who shall try the case himself. With regard to the objection raised by accused Dr. Dinesh Bhatia, reference is made to the decision reported in Lieutenant Commander Pascal Fernandez versus State of Meghalaya, Maharashtra, AIR 1968 SC 594, relied upon by the accused person Dinesh Bhatia. Reference is made to the decision of Surendra Chandra Bahari, State of Bihar, so and so. In Lieutenant Commander Pascal Fernandez versus State of Maharashtra, the Honorable Apex Court has held as under. In this case, the special judge made no effort to find out what Jagasia had to disclose. The English law and practice is to omit the proposed approver from the indictment, or B, to take his plea of guilty on arrangement, or C, to offer no evidence and permit his acquittal, or D, to enter a nolle prosequi. In our criminal jurisdiction, there is a tender of a pardon on condition of full disclosure. Section 8.2 of the Criminal Law Amendment Act is enabling. Without recourse to it, an accused person cannot be examined as a witness in the same case against another accused. To determine whether the accused's testimony is an approver is likely to advance the interest of justice, the special judge must have material before him to show what the nature of the testimony will be. Ordinarily, it is for the prosecution to ask that a particular accused out of several may be tendered pardon, but even where the accused directly applies to the special judge, he must first refer the request to the prosecuting agency. It is not for the special judge to enter the ring as a veritable director of prosecution. The power which the special judge exercises is not on his own behalf but on behalf of the prosecuting agency, and must therefore be exercised only when the prosecution joins in the request. The state may not desire that any accused be tendered pardon because it does not need approver's testimony. It may also not like the tender of pardon to the crime or the worst offender. The proper course for the special judge is to ask for a statement from the prosecution on the request of the prisoner. If the prosecution thinks that the tender of pardon will be in the interest of successful prosecution of the other offenders whose conviction is not easy without the approver's testimony, it will indubitably agree to the tendering of pardon. The special judge or the magistrate must not take on himself the task of determining the propriety of tendering pardon in the circumstances of the case. The learned special judge did not bear these considerations in mind and took on himself something from which he should have kept aloof. All that he should have done was to have asked for the opinion of the public prosecutor on the proposal, but since the public prosecutor, when appearing in the High Court, stated that the prosecution also considered favorably the tender of pardon to Jagasia, we say no more than to caution magistrate and judge in the matter of tender of pardon suo motu at the request of the accused. This practice is to be avoided since the prosecution in the case also wants that the tender of pardon be made it is obvious that the appeal must fail, it will accordingly be dismissed. The second judgment, my lord, in Suresh Chandra Bahari so-and-so, it has been held. We have already reproduced above section 306 of the Code of Provision, of which apply to any offence triable exclusively by the Court of Special Judge, to any offence punishable with imprisonment extending to 7 years or with a more serious sentence. Section 306 of the Code lays down a clear exception to the principle that no inducement shall be offered to a person to disclose what he knows about the procedure. Since many times the crime is committed in a manner for which no clue or any trace is available for detection, and therefore pardon is granted for apprehension of the other offenders for the recovery of the incriminating objects and production of the evidence which otherwise is unobtainable. The dominant object is that the offender of the heinous and grave offences do not go unpunished. The legislature, in its wisdom, considered it necessary to introduce this section and confine its operation to cases mentioned in section 306 of the Code. The object of section 3046, therefore, is to allow pardon in cases where heinous offence is alleged to have been committed by several persons, so that with the aid of the evidence of the person granted pardon, the offence may be brought home to the rest. The basis of the tender of pardon is not the extent of culpability of the person to whom pardon is granted, but the principle is to prevent the escape of the offenders from punishment in heinous offences for lack of evidence. There can therefore be no objection against tender of pardon to an accomplice simply because in his confession he does not implicate himself to the same extent as the other accused, because all that section 306 requires is that the pardon may be tendered to any person believed to be involved directly or indirectly in or privy to an offence. In view of the above direction, there is no merit in the objections raised by the accused, Dr. Dinesh Bhatia. The petitioner accused number 3 herein is in the complainant, and it is on the basis of his complaint that the case came to be registered. The petitioner accused number 3, Raghavendra Pratap Tripathi, in his application has also stated that he is willing to make a full and true disclosure privy to the offence in totality before the court. In view of the decisions referred to above and the fact that CBI has no objection to the tender of pardon to the accused person, Raghavendra Pratap Tripathi, and that the accused is ready to make a full and true disclosure privy to the offence before the court, the application filed by the accused person so-and-so for grant of pardon under 306 CRPC is allowed. The accused is hereby tendered pardon under section 306 CRPC on the condition that he shall make a full and true disclosure of the whole of the circumstances within his knowledge related to the offence and to every other person concerned, whether it's principal or abetted in the commission of crime, commission thereof. Petition number so-and-so, filed by the petitioner, is hereby allowed and disposed of. Now, my lord, what comes out from here, my lord, that court is not to jump into the picture, not to act as a, it has to see the prosecution's interest, whether disclosure of that granting of pardon to one of the accused will result in conviction or a successful trial, my lord. That is one parameter, my lord. And second parameter in the first judgment was that it says, my lord, that it is for the prosecution basically, because they are prosecuting the case. If they agree to grant a pardon, then court.
It is not for the court to see.
No, not for, yes, to that extent, my lord. Now here in the previous part, at page 20, lordship, we've seen the CBI has submitted before the court that they have no objection to grant of pardon, my lord. And on the basis of that, that has also been taken into consideration in this second last paragraph by the court, that where it says, my lord, in view of the decision referred to above and the fact that the CBI has no objection to the tender of pardon to the accused person and that the accused is ready to make full and true disclosure, a petition is allowed, my lord. So, my lord, in my humble submission, there is no jurisdictional error under 397 or 401, my lord. That's one aspect, my lord. The second aspect, what my friend was submitting, my lord, section 8 of the PC Act.
306 has nothing to do with section 8.
My lord. In fact, the grant of pardon is...
It is not dependent on whether...
he reports it or not.
It is not on this.
Because if he reports within 7 days, my lord...
Here, sorry.
My lord.
Here the thing is that, here the person who was granted pardon, he himself was a complainant.
My lord.
And what appears from the provision of 306, that it is not dependent on that
provision of section 8 of
My lord.
that where the innocence of the
My lord.
pardon seeker has to be determined first. And that is what the 1995 decision where the trial court has said. It said it is not the culpability, the amount of thing. You have to see whether granting pardon would bring success to will help the disclosure of truth before the court. That is what.
And it is not even dependent on who committed the main crime, my lord. Whether he was only a accomplice in that judgment, it says that even the main accused can be granted pardon.
The basis of the pardon, the basis of the tender of pardon is not the extent of the culpability of the person to whom pardon is granted. But the principle is to prevent the escape of the offenders from the punishment in heinous offences.
And that's one part, my lord. And lordship, today, of course, this submission was not made, my lord. They are denying the power of CBI court, my lord, to grant pardon. Now, it is
not been argued by this.
It has not been argued today, my lord. Because Section 5 of the Prevention of Corruption Act also contains similar provision, my lord.
Anyway, if it is not argued, it's okay. We will not go into all those things. Why should we get involved? Anybody appearing for private respondent?
Mr. Thapa is there.
Yes. Then we'll close. We'll say that nothing has been argued. It's okay, but then you see, somebody has to be there. See,
Are they opposing or supporting? It is that much.
see, somebody has to be there. It cannot be in the midst of the hearing you leave this court and go to attend a hearing in other court. It cannot be. We will say that you have not addressed the court. Opportunity means what? By saying yes, so say court is basically waiting for your address. Then your address, come here, come in front of this and just say what you have to say.
May it please your lordship?
Yes.
Lordship, I do humbly pray, lordship, if this matter may be listed another time, lordship.
Another time? No, that is, we have heard substantially.
Lordship,
We want it to be listed in some other time.
lordship, I have not been given any instructions, lordship, in this matter.
So,
I do humbly pray, lordship.
Yes.
My learned senior has already covered, my lord. But
any
if they are
interference
not
made
there,
will definitely affect him. That is the main thing. He's right. Then he'll have to again go through the rigor of the trial. He has to face.
He has not challenged this.
No. But then any order, if we allow the petition, then that will go against him. He will affect his right. If this revision petition is allowed, then what happens? The pardon granted by that court below stands interfered, and then his status will go back to an accused again. Tomorrow or day after, we'll continue.
Tomorrow, lordship.
tomorrow it is difficult for me, my lord.
Day after? Otherwise, you see, if it goes by one thing, then you'll have to refresh the court again. That is the main thing.
That is the.
We can keep it in the next week, but then on the condition that you have to refresh the court. Are you agree to do that? What about day after?
Day after already.
We'll have it after tomorrow. You have done your part. If you are engaged, then you can leave your things. This court has understood your submission. Two things. One is that once prosecution consents to it, that should be the final. That should be the final say. The court will not determine and go into the question whether that has been done validly or not. And second thing, it is not the culpability of the person who, the amount of culpability which the person has been granted. It is whether you have to see that the wrongdoers is punished. That is what is common submission of it.
So that's why there is no jurisdictional error to put interference.
Anyway, just hard letter counsel with the parties. list, just give day after tomorrow for further hearing.
I'm grateful.
Day after tomorrow, you will call it first before calling other things. Yes. Okay.
Yes, come. He's here.
I'm sorry, my lord. Something
The
came
court
up.
has made passed an order listing day after tomorrow. Now it cannot be like that. See, you
I'm
leave
so
leave at
sorry.
the midst of the hearing, you go away, then you come back again, and you leave
I'm
your
so sorry, my lord.
person without any instruction. No, that is not
I thought,
something.
my lord, I'll get by the time my learned senior finishes, I would be able to come back, my lord.
Then you should have left behind some instruction.
I'll just take, my lord,
You
if
cannot
your
just
lordship
leave
allows,
her
my lord,
helpless with the.
I'll take 2 minutes, my lord, because besides what my learned senior has said,
Okay. Then it's okay. Then we'll
I'll
finish
adopt
it.
what my learned
Yes.
senior has said.
Let us finish. Yes. You do not cancel that order. Yes. You are appearing for response number
2, my lord.
Yes.
Lord, first of all, my lord, I'll adopt what my learned senior has said. Besides that, I'll make
What he has said.
my lord, he's gone very elaborately through the judgment passed by the learned trial court. My lord, the decision that the learned trial court has cited perhaps will, my lord, squarely cover the case.
On what point?
On a point that, my lord, in such a case where, my lord, I'm the complainant and it is based on my complaint, my lord, the prosecution, the wheels of prosecution has been started.
But the decision cited by the trial court is not on that point.
Not on that point, my lord, but she has also she has also made an observation to this effect. My lord, I will...
No, that is, you see, you are mixing up. First you say what you are saying. You are endorsing the submission made by
Right,
Dr.
my lord.
Mojika.
Besides that, I'll make 2
No,
points.
endorsing
my
the submission. Which submission?
My lord, regarding the culpability, my lord, the trial court is not required.
Dr. Mojika has only read out the order. He has not made any submission.
My lord, of course, I could not follow him quite thoroughly for the entire.
So before endorsing, you see, he has basically prayed for allowing the petition.
His petition, my lord.
Yes.
That cannot be. Anyway, my lord, my lord, here in.
Before you make a submission, you be sure what you are saying.
My lord, I just heard him.
It should not be an assumption.
Relying on the
You
trial
have the
court's
risk.
order.
You do not know what has happened. Because when Dr. Mojika had made the submission, when he summed up, you were not here.
Right, no. I'm so sorry.
Then?
My lord, because I heard him relying on the trial court's order.
Anyway, you just say.
My lord, only thing, my lord, here, referring to section 8, my lord, may kindly appreciate one thing.
Section 8 has no bearing.
No bearing, my
There's
lord.
no
Here,
bearing.
here, my lord,
306
by
doesn't
virtue
say
of
that
section 8,
it has to be with reference to the innocence of the pardon seeker. It has
Right.
never said it.
Right, no, absolutely. No, what I'm trying to implore upon this honorable court, my lord, is section 8 basically provides me an impunity. My lord, the proviso section 8, it is only, and that impunity is contingent to one condition, that if I, my lord, report the matter within 7 days or 8 days.
Not going.
That was not done, my lord. That is why I have been
What
implemented.
bearing it has here?
No, my lord. Why?
See, 7 days and 8 days comes, the period of computation of that thing comes, just for the purpose of determining whether we should be free of the liability of this case.
Correct.
We are not on that question. It is in pardon. The law doesn't say that the presumption of innocence has to be there with the pardon seeker. Is it there?
No.
306 what Mr. Dr. Mojika has made out, it is not there.
Not there.
It is what the law contemplates is that once the plea is supported by the prosecution, once it comes to the prosecution, it should not be normally doubted by the court.
Right. And if on top of coupled with the fact that the prosecution says they have no objection, because it is their case and they are in a position to better understand.
You just say something else. If you have adopted Dr. Mojika's thing.
No, my lord, I'll
then
just
you say
place
original
one
point
judgment of the Madras High Court, my lord.
What does it say? On what point?
On 306 only, my lord.
Yes.
Because, my lord, here they have not, my lord, they have
What
not
about the locus
expressed.
standi of a co-accused? Just elaborate us on that. The locus standi of a co-accused in a criminal trial when it comes to this kind of situation.
The locus standi as in me, my lord, or
of the petitioner.
Malad, that is why I'm saying, Malad, they, first of all, they have failed to show
The decision cited by Mr. Pandit.
on what ground, Malad.
Have you
They
were
have not
there
supplied
when-
me a copy, Malad. I was there, but they did not supply me a copy. They were more on 397 and 401. Malad, what I'm trying to Malad, impress upon this honorable court is they have failed to show on what basis they have been prejudiced by passing of this order. That is number one. Number two, my lord, the power under
he said that
306.
he will suffer. Once you become prosecution witness, he will suffer. He says he will be highly prejudiced. He said.
No, my lord.
Because
Here, if I make a full disclosure of what I know, my lord, the causing of prejudice to him or not causing any prejudice will hardly be any relevance to him.
So then you just do not say. You said that there is nothing to show prejudice.
No, my lord, he has to show.
That is why this quoting us,
that
asking you.
By granting pardon, my lord, I have been prejudiced. He has been prejudiced.
Just tell us what is the locus of.
No, he doesn't have any locus, my lord.
Just on what basis you say? If you say if it is not there, then what basis you say?
Because, my lord, here the power under 306, which is vested on the trial court, my lord, is a discretionary power. And if she applies that discretion, my lord, taking note of the materials on record and also the no objection by the prosecution, my lord.
Yes.
In that case, that discretion cannot be faulted, my lord, especially by the co-accused. Now, I'll take your lordship to...
No, what kind of grievance legally a co-accused can raise in this kind of situation?
Well, he has a right to cross-examine at an appropriate stage.
No,
Besides
grievance. I'm not talking what he will do at that stage of trial.
Well, he cannot raise any grievance
if grant of pardon to one of the co-accused, what right the other co-accused has, or what grievance the other co-accused can legally raise in this kind of situation?
He can of course challenge that order, provided he shows that he has been prejudiced.
So now badly. again, when the court has asked you that question, you said the question of prejudice is not a question here. Now, if he says the prejudice...
No, he can file for revision or whatever, my lord, but he can challenge that order. He can challenge that order provided he is in a position to show.
The core question is that if you have anything on that, you say yes. If not, then you say no. The core question what this court is asking, that in this kind of situation, against the grant of pardon to a co-accused, if it is challenged by another co-accused, what can be the limited ground on which it can be challenged? Well, do you have any idea about that?
My lord,
of course, you may say that it is not for you to say, it is for Mr. Pandit to say. But then Mr. Pandit, as you say, you have seen that he has cited a decision elaborating the scope and power of this High Court under revisional jurisdiction, and where in such a situation, according to him, the court can take suo motu notice also. But then when the question of taking suo motu notice comes, if at all we have to ignore that part, the locus of the co-accused, locus of the petitioner here, then what can drive this court to interfere in this kind of situation? And when court should desist from doing that?
Now, if there is any procedural lapse resulting in causing prejudice to him, if that is not there, my lord, in my humble and respectful submission, he would have no case to challenge that particular order. I'll just take your lordship to very quickly to one order, my lord, judgment of the Madras High Court. My lord, this is 2002, Volume 1, CTC 143. I'll take your lordship to the relevant paragraph straight away.
That is single bench judgment?
Single judgment, my lord. Para 12, my lord.
In this kind of situation, is it identical situation?
Very, very much, my lord, because it concerns 306 only.
Yes, Para 12.
Yes. My lord, it is a settled law as laid in Fakir Singh versus Emperor, AIR 1938, Privy Council 266, Kochar versus State 1969, Criminal Law Journal 45, that the co-accused cannot question...
You are reading paragraph?
Para 12.
Yes.
That the co-accused cannot question the act of granting pardon by the court to one of the accused, as that is an internal matter of administration which cannot affect the position of the accused or the approver. The tender of pardon and its acceptance by the person concerned is a matter entirely between the court concerned and the person to whom it is made. If the tender of pardon is accepted by the accomplice concerned, the only obligation placed upon the prosecution is to examine him as a witness in the case. Now, para 15, my lord, the pardon proceeding which takes before the magistrate is neither an inquiry nor a trial in which an opportunity must be given to the other accused to show to the court that the statement of the accused seeking pardon is not true. Only during the course of trial, the opportunity will be given to the accused to show to the court that the approver's evidence at the trial is untrustworthy in view of the contradiction or improvement made by him by allowing the accused to cross-examine. Para 17, Malad. Similarly, the accused cannot question the stage at which the pardon has been granted. As a matter of fact, Section 306 CRPC would provide that the Chief Judicial Magistrate or any magistrate of the first class inquiring into or trying the offence may tender pardon at any stage of the inquiry or trial. Now, Malad, Para 22 of this same judgment, Malad, it will be also relevant. Section 306 CRPC would provide that while granting of pardon, all that has to be seen by the court is as to whether the approver was directly or indirectly concerned with the offence, or he was supposed to have been privy to the offence. The emphasis is on the word supposed. This word supposed does not mean that such a person should have fully participated in the crime. Thus, the very basis of the section is that a person who applies for the pardon under the provision of Section 306 and 307 can be assumed to be directly or indirectly concerned in the offence. Similarly, he may be assumed to be privy to the offence. Thus, the person applying may not be actual culprit, and there does not arise any question of exculpating one's own self. Further, such a person should be supposed to be directly or indirectly concerned or privy to the offence. Meaning of the term concern also shows that such a person may be somehow directly or indirectly concerned with the offence. He may have some interest therein, or the incident which led to the
your case, it is okay. You do not have to go into it.
Right.
The fact remains that you are the complainant.
Yes, my lord. So, my lord, in my humble and respectful submission, my lord, the order of the learned trial court, my lord, do not suffer from any infirmity, and as such, my lord, this revision application deserves to be dismissed and rejected.
Okay, my lord, one more submission. I just want, if you could allows me, one more submission.
Only reply to their thing.
All right. Yes. My lord, 306 says that with view to obtain evidence. My lord, here the petitioner, the respondent number 2 who has approached the trial court, he has not he has not cited anything what he want to disclose. He is totally put us in dark.
Where is that?
Based on what? No, but based on what material the learned trial court has.
Where is the requirement of doing that?
No, with a view to, there has to be some material before the learned trial court.
What some material that is for the trial court to
what he
appreciate.
wanted to say.
It is
because he has already.
Just tell us where is the requirement that what he would supposed to depose has to be given in advance. Where is that?
In that judgment
the
also.
Contents of this evidence.
Yes. My lord, this judgment, if I will be allowed to place this one High Court, Punjab and Haryana.
What does it say?
The purpose of this 306.
Yes.
It has been.
Just read it out. First read it out. Just say what is there.
The question was framed by the Honorable High Court was, can pardon in terms of Section 306 be termed as beneficial legislation for the benefit of accused, as is pardon granted in terms of Article 72 of the Constitution of India? While grant of pardon certainly turns out beneficial to such accused, who is granted pardon as he would be spared from the penal consequences of conviction. But the object and purpose of Section 306 CRPC is not just to extend benefit to an accused, but is to enable the prosecution to obtain evidence, particularly where there is lack of evidence to substantiate the case of the prosecution, as in the case of conspiracy, where conspiracy is hatched in secrecy in regarding certain modus operandi in respect of which complete clarity is not there. But in this case, there is everything is there. So, Honorable...
There is nothing, nowhere it doesn't say that the details of the things has to be given.
No, but there has to be certain materials, my lord, so that I'll just place this one, my lord. It will be helpful for my lord. Only paragraph number 20 and 21, my lord. paragraph number 21 and 24 will be relevant, my lord.
How far binding this judgment will be on this?
No, it is not binding, my lord. Just
21 and 24.
yes, my lord.
Yes. Anything more? No. We'll pass order. Yes.
Item number 23.